Good evening. This is John Milburn for Laws 12059 Conveyancing. This is week 8, and we're covering initially week 7 material, the subject matter of the sale. You'll recall that last week we began our discussion with respect to the deposit, and we understand that the deposit is a part payment, but it's also a form of security in an informal sense. It's, if you like, a statement that someone is earnest about the transaction, and it's something which is to show that the party is serious about proceeding. Before I go into a case scenario where I really want you to pay attention, let's have a look at the standard contract. With respect to the issue of deposit, in the reference schedule, you'll see on page 3, there is a notation of deposit. Under the heading of price, we have deposit holder, deposit holder's trust account, bank, and other details. Prior to that, and then we have deposit just underneath that, my apologies, in 2 parts. Initial deposit payable on the day the buyer signs the contract, unless another time specified below, and then the balance deposit, if any, payable on a certain date. What's a little confusing from a drafting perspective is that some of these terms are capitalised as if there was a definition that applies to them. So the words initial and deposit are both capitalised. The words balance and deposit are both capitalised. But if you look in the item schedule, in the definitions schedule number 1, there is no definition for those, even though there is a definition of balance purchase price. So I think the definition is really that which is contained in clause 2.2 and 2.3. And as we speak, I notice the GST provision above that, which may be relevant in some circumstances. So do have a look at 2.2 and 2.3, which deal with the payment and then investment of the deposit, and importantly, 2.4, which talks about an entitlement to a deposit and interest. Now, just before I get onto the case scenario that I want you to really consider carefully, have a look at clause 2.41, because I want you to ask yourself this question. Let's assume, for example, that you're acting for someone, a buyer or a seller, it doesn't matter, in a conveyancing matter. Let's assume that it's a long-term contract, $1 million contract, deposit of $100,000, and it's subject to, let's say, a property development or a sale of property, and the contract is a 12-month contract. At the end of the 12 months, let's assume that it settles. If you're acting for the seller, your client says, well, that's great, I'll have the deposit, and by the way, where's the interest? Conversely, if you're acting for the buyer and it doesn't settle at the end of the 12 months, the buyer says, thank you very much, thank you for recovering my deposit, by the way, where's the interest? So whilst it's probably fair to say that in practice, we don't ask the deposit holder to invest the money, or at least to do so readily, bear in mind that provision, which it would be your responsibility as the conveyancer to advise the client about, and the obligation on the deposit holder to invest the money if either the buyer or the seller request it to be invested. Okay, now, having considered the deposit, clauses 2.2, 2.3, and what's in the reference schedule, listen very carefully, because I have a scenario and I'll be really interested for your thoughts in relation to it. Case number 10. Seller instructs you to terminate a contract. You act for the seller. The seller comes to you with a contract delivered by the agent. The sale price is $1 million. And the deposit is payable in 2 parts. The initial deposit, $10,000. The balance deposit, $90,000, payable within 7 days of the date of contract. The seller asks you to contact the agent to verify that the buyer has paid the deposit. That is, whilst the seller's with you in your office. So you do. You contact the agent who says the buyer has not yet paid the deposit but has promised to do so within the next couple of days. Your client, who's still sitting opposite you, signs the contract and instructs you to advise the agent of acceptance, bearing in mind that we need offer, acceptance, and communication of the acceptance. So that happens. You're sitting there with your client in front of you, and as requested, you contact the agent to say the contract is signed, and you ask the agent to contact the buyer to confirm the acceptance. You stay on the line while the agent goes off on another line and makes the call. You're just chatting to your client for a few minutes. Then the agent comes back and says, yes, I've confirmed to the buyer that you have accepted the contract. The agent advises the buyer is now aware that the contract is signed, and the agent passes on a message to your client via you saying, congratulations on the sale. Finally, we got a buyer we needed at the price we wanted, $1 million. You hang the phone up. You now want to start talking about the conveyancing process, but before you can go into, if you like, your standard spiel, your client shocks you by saying, all right, thank you very much. I now want you to immediately terminate the contract. I want you to declare the full deposit is now due and owing as a debt. And I want you to put in the communication that I reserve the right to sue for damages if I'm unable to secure $1 million on a resale. So do you understand the scenario? So the first thing is, do you act on those instructions? Is it ethical to do so? What advice would you give to the seller? Any thoughts?
The buyer's in default because he didn't pay the initial deposit at the time of signing the contract.
Yep.
So that provision yep.
Yep. So does anyone disagree with that? Yep. So I think clearly the buyer is in default. Okay. And that's because of a combined reading of clause 2.2 in combination with the information in the reference schedule.
Correct. And also, even if they were to pay the $90,000, you would then be in an instalment contract. Oh no, it's 10%. Yeah.
Yeah, just on 10%. Yep.
Just on 10%.
But good thinking. I like the way that you thought about that aspect. All right. So would you act on that? And you'd say, well, we're terminating the contract. The agent's going to get on the phone to you and say, what do you mean? I just 10 minutes ago, you told me that you've accepted the offer. Now you're terminating the contract. What, do you want to back out of the deal? No. All I'm doing is claiming my right under the contract to pursue. Now, Sarah says, is this unconscionable? That's a good point. Is it unconscionable?
I thought that you said the agent had said that the buyer will pay the balance deposit in a couple of days, and that was agreed to between the parties before the agent rang back to the buyer.
Well, I'm not sure we can say it was agreed to, but the seller was aware of the fact that the contract, that the buyer had not signed it. But your instructions were not to say, that's okay. But it's a fair point. So there's a conflict there, I think, between the technical provisions in the contract and a justifiable argument that it might be unconscionable conduct in the circumstances. Is it ethical for you to act on your instructions? Rachel, what do you think? No, I think we've just got a bad line there with Rachel. Yes, Rachel.
Speaking, but well, the first thing I was going to say was that on the contract it says unless another time is specified below. So if in the contract the within a couple of days was specified, then that would be okay and the buyer wouldn't be in default. But do I think it's ethical? No, not really, and I'm not sure why.
Yeah.
I don't like it. Something's rotten in Denmark, but I can't work out what it is.
Yeah, it's nasty.
I think it's a type of entrapment.
Something along those lines. Yeah. So unconscionable, and for the moment, we'll assume that there was nothing in the contract that said the deposit might be payable within a few days. All right. So there are a few issues there. One thing that you might consider is whether the failure to pay the deposit is a failure of a condition precedent or a breach of a contract. So do you know what I mean by a condition precedent as opposed to a condition subsequent? So a condition precedent goes to the very heart of the existence of the contract. So, but most contracts, most clauses in a contract are condition subsequent. In other words, the contract exists, people have actions and rights under that contract, which will entitle them to argue for a breach or not. But the first thing is that you might argue, if I was on the other side, I might argue that in these circumstances, given the statement that was made, either it was unconscionable or it was a condition precedent. I'd start probably with the saying it's a condition precedent. That's a tough argument because that's not usually the way we view these sorts of conditions. So if it was in fact a condition precedent, then the seller has no remedy in those circumstances. Have a look. Yes, and Bronwyn said that a note that the balance deposit was payable within 7 days. That's correct. But the question is, and this is another aspect of the question that I've raised is, if the initial deposit is not paid when due, is that sufficient to warrant a seller in general terms having the right to terminate the contract, or do they have to wait until we get to the stage of the balance deposit payable? In my view, the breach occurs on failure of payment of the initial deposit. You don't have to wait until the balance deposit is due. Now, here's a case, Alarm Facilities Pty Ltd against Jackson Constructions, 1975 to New South Wales Law Reports 22. The New South Wales Supreme Court favoured the view that it was a default under the contract. Not the exact circumstances that I've mentioned, but it was a default under the contract as opposed to a failure of a condition precedent. So what are the other clauses that we need to consider if we were answering a problem around this in a take-home exam? We've identified clause 2.2. What do we make of clause 2.2 subsection 3? And I trust that we all have our standard contract. And I must say that I'm still working off the 14th edition, which is what I said I would do, even though we switched over to the 15th during the time the unit commenced. So 2.2 subsection 3 says, the seller may recover from the buyer as a liquidated debt any part of the deposit which is not paid when required. Two things there. Let's assume for a moment that your client could actually sue for the deposit. Could your client sue for the $10,000 or the $100,000? $10,000, $10,000, $10,000. We're getting a lot of votes for $10,000. Could you mount? Leonie says $100,000. So we're getting 3-1 now in the voting. So if the buyer was only liable to pay the $10,000 at that time, it might be tempting to say that's all that you can sue upon. However, my view is that if the contract is terminated, then the full deposit is payable. So, but that's a grey area. But I think I would certainly sue for the full $100,000. The reason is they're in default, and the basis for a deposit is that it's a forfeitable amount. Rachel, any thoughts?
I was just going to say that if the seller has told you to terminate before that, because I think you said that the 7 days, the rest of it was due 7 days before settlement, given that they've already terminated, that 7 days isn't going to occur, is it?
No, it's not. No.
So it's a pretty touchy sort of argument, isn't it?
It is, but so it really comes down to what is the purpose of the deposit. So part of the reason I'm asking you that question is, what is the deposit? Partly, it's a part payment. It's a statement that the buyer is earnest, but also an intention of a deposit is it's an amount that the parties agree is liable to be forfeited in the event of the buyer's default. So on that basis, I think it's certainly arguable, if you're acting for the seller, that you'd pursue the full $100,000, not just the 10. So clause 2.23 is relevant. Are there any other clauses in the contract? Don't worry about the cases for the moment or statutes, but just in the contract, are there any other clauses that come to your mind that might be relevant to an argument, one way or the other? 9.1. 9.1 says, what does it say, Sarah? I agree with you.
It refers to the party's default. So in the circumstances that a seller, let me just read it, sorry, or any party, fails to comply with an essential term or makes a fundamental breach of an intermediate term, the seller or the buyer may affirm or terminate this contract. And then you can refer down to the other clauses with regards to what they can sue for and the sort of remedies they can make.
Excellent. All right. So I think that's an excellent place to start looking. So you've got these instructions from your seller. Something smells rotten in the state of Denmark. You don't like it, but you think, I've got to follow through with my client's lawful instructions. You look at clause 9.1, as Sarah quite rightly points out, and it says, can I ask myself this? Is the buyer in default? Has the buyer failed to comply with an essential term? In which case, the seller may terminate, amongst other things, the contract. So is the payment of a deposit or part of the deposit an essential term? And where do we find what's an essential term and what's not? So we're getting votes saying yes, it's essential. The fact that essential and the term are, Bronwyn's got it. The word essential is capitalised, the word term is capitalised. So that indicates to us, more than likely, we need to go to the definition section. So we go to the definition section, and essential term includes, in the case of a breach by the buyer, various clauses. So it's 1.1 is the definition clause. So Sarah has identified which of those clauses that relate to the buyer might be essential terms. Which one do you think the buyer may have breached? Which essential term? 2.2 seems to be the vote. All right, so what's 2.2 say? Now, it says the buyer must pay, so it's cast in obligatory terms, must pay the deposit at the times shown in the reference schedule. The deposit holder will pay the deposit until entitled to it. So it doesn't say at the time or the last time nominated. It says at the times plural. Now the question is, does that mean must pay at both times, or is a failure to pay on one sufficient to justify taking action from the seller? I suspect failure to pay on one occasion is enough. Are there any other clauses? So we've identified 9.1, 1.1, 2.2 Are there any other clauses that might be relevant? Is time of the essence? Is time of the essence on this point? Sarah says 2.5 regarding the balance of purchase price, the balance deposit. That was not, I didn't put that on my list, Sarah. Is there somewhere in particular in 2.5 that springs to mind? .4 says Leonie, which is to enable the deposit on termination. Yep, so 2.4. 2.5 is an essential term. All right, what about time of the essence? What if they say, yes, but we weren't obliged to pay, even though the contract says pay at that time? What's the time of the essence clause in the contract? 6.1. Does that time of the essence clause apply only to settlement, or does it apply to other dates in a contract? If we look at 6.1, it says time is of the essence of the contract except regarding any agreement between the parties on a day of time of day for settlement. So it seems to indicate that time is of the essence of any date within the contract. Okay. Now, what are the options available in general terms for a seller who terminates a contract? What are the options available to a seller in the contract? What clause says, here are your options? Okay, we're getting a few different votes coming in. 9.4, Leonie and Sarah. That's the one I had in mind. So 9.4 says that if the seller terminates, and that's what your client purports to do, it may resume possession of the property, forfeit the deposit, sue for damages, and resell the property. Can it do all of those things, or does it have to choose? Sarah says it can do all of those things. Any or all. I agree with that. And that's the votes coming in. So any or all. So when the client says, yep, I'm just going to take back my property, forfeit the deposit, sue for damages, I'm going to resell the property, and they'll have to pay more if I don't secure the $1 million.
There's just one problem though.
Yes,
John.
Rachel. Yep.
Day hasn't finished, so the buyer
That's a
can
good
still
point.
pay the deposit sometime before 5 p.m.
That's an excellent point. But that's an excellent point. And that, I was waiting for someone to say that. So thank you. That's a really good point. Although, you know, what's the provision that would say the day is relevant? Because 6.1 only talks about time of the essence not relating to an agreement about the day. But I think you're right. I think that would be the real concern for the seller.
I think I'd just go to the main part of the contract, which is page 3, which says that's payable on the day the buyer signs the contract.
Yes.
So I'd give them till the end of the business day.
Okay. All right. So for the sake of argument now, what we'll assume is that the seller comes in the next day and does all this rather than on the day of signing. So we'll make it just a little bit more confronting. But that's a really good point. Thank you. Okay, so other clauses, 6.1, 9.4. What about reselling the property? What if let's assume this happens, and instead of getting $1 million, the seller secures a contract for $900,000. Given that the seller can do all or any of these things, does the seller keep the $100,000 they sued that should have been the deposit And do they sue for the extra 100,000 because that's the shortfall? Or does one offset the other? My view is that one offsets the other, that you can't have two bites of the cherry there. But I'm not sure that I've got an authority for that, but I'm pretty confident that's right. Okay, so some other issues. Is there, before you terminate a contract, do you have to give the other side notice of your intent to do so? In general terms. If you say that they're in breach, do you have to put them on notice? Do you have to say, I'm giving you notice that you're in breach and I'm giving you an opportunity to remedy the breach? Some votes? Yes and no. Any other votes? Do you have to give notice, or can you just, is it a guillotine situation? In this contract, in this context, no. So the votes are coming in no, so you don't have to give notice. Perhaps you'd argue that it was unconscionable of the seller in these circumstances. Perhaps you'd argue a estoppel may be relevant. So it's a very tough approach, but is the approach that your client is taking consistent with the whole let the buyer beware philosophy? Maybe it is. All right, so thank you very much for that. I'm just going to advance this a little bit more. Let's assume that you say to your client, no, you can't do that. I'm not acting on your instructions. And to overcome the problem that Rachel correctly identified, let's assume that all this occurred on the day after the contract was signed, but before the deposit was paid. You say to your client, no, you can't terminate the contract. That would be unconscionable of you to do so. Your client says, well, if that's your advice to me, I'm not happy about it, but I'll proceed. Settles, then 6 months after settlement, your client comes in and says, knock, 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 this property's been rezoned, it's now worth $1.5 million. You should have let me terminate that contract when I asked you to do so. So now you owe me $500,000 because I've had advice and you did actually have the ability to terminate, so you gave me the wrong advice. What do you do then? Call Lexon. Yeah, that's what you do. Go talk to the insurer. That's it. So Lexon is the insurer for conveyancing. Now, on the other hand, what if the scenario occurred, but you're acting for the buyer? So the buyer comes to you and says, just been told that the contract's been accepted. Then the next day, the seller pulls out just when I was about to get the deposit paid. That's not very fair. What would you do about it?
I guess you'd try and contact them and find out why, to find out if there was any way of remedying what had gone wrong.
Yes. So some sort of informal negotiations, discussions. I think that makes sense. Let's assume that you're just dealing with a really difficult person who says, just because I can. So you'd probably try to seek a remedy through the court, but it's a tough one. And just before we leave this, so there's a general statement of saying, gee, it's really unfair and I don't like it, and I agree with you. But can I ask you this conceptually? What if we were talking now about failure to pay the balance purchase price instead of failure to pay the initial deposit? If settlement was due on the 30th of September and the buyer was not able to settle on the 30th of September, would you have any concerns about terminating the contract on the 1st of October, if that was your instruction? Probably not. So I guess the point that I'm drawing there is the difference between a payment. Is it different in character if it's part of the deposit, or if it's part of the purchase price, the balance purchase price? In my view, probably not. Now, let's have a look at a case, a real case, Brian against Dwyer, 1978, 141 CLR 378. This was for the contract of sale of land. The deposit was to be paid upon signing of the agreement. and the buyer did not pay the deposit of $1,600. Bear in mind, this is 1978. The deposit, the contract said that the deposit could have been paid by cheque, and the sellers did not know that the buyer did not know, the sellers did not know that the deposit was unpaid. The buyer had provided a post-dated cheque. The High Court said, and have a look at paragraph 17 of Chief Justice Barwick's decision, no doubt an intending vendor who knows the buyer has not paid the deposit will be justified in not making a contract with him, but if ever having signed the contract in ignorance of the failure to pay the deposit, the vendor becomes aware of that failure, he can immediately, in my opinion, and without prior notice, out of hand rescind the contract. Very similar to the scenario, it's just that in the first scenario you did have notice. Quite clearly, says Chief Justice Barwick, in my opinion, he is not bound to wait any time to allow the buyer to pay the deposit, nor is he bound to give notice of a requirement. In my opinion, Clause 1 effectively does that, nor is he required to give intention of his desire to rescind. So Stephen J. Approved of the New South Wales approach by saying at 397, it should not be regarded as a condition precedent to the formation of contractual relations. Comes back to the very first point, if you want some authority about whether it's a condition precedent or not, but rather a condition subsequent of a special character. It's a special character for a deposit that requires a buyer's failure to pay at the time in the manner stipulated, then there is a right of a seller to terminate the contract. So if you're looking for a case that would advance the argument for the tough approach, that's probably the starting point. Okay, let's move on. Thank you for participating in that little scenario. Obviously, when you're looking at the subject matter of a contract, you need to very carefully consider and check the reference schedule. Failure to do so may mean that your client's rights are lost or diminished, and there may be an allegation of professional misconduct or negligence. So when you receive a contract, you've really got to scour through it very carefully. And in my view, if you see something which would entitle your client to take action, even to terminate the contract, they may not want to, but I think you're obliged to let them know of their entitlement to do it and have their clear instructions, and notwithstanding that, they wish to proceed. Does that make sense? That's if you're acting for either party, really. Let's have a look at survey. Now, is there anything in the standard contract that deals with survey? If so, where would we find that? And I guess what I like to do is look through both the reference schedule and the special conditions. Or if you like, sorry, the standard terms of contract. 7.5, that's it. So a buyer may enter upon the property to survey the land to determine the boundaries in the area and find out whether any encroachments exist. The buyer can terminate if there is an encroachment or mistake which is material, but if not, can seek compensation. So the case on whether or not it's material was Gordon Linton Liverpool Holdings and Gordon Linton Car Sales. I think that's 1978. And there's a comment from the High Court in Svazanio, SVANOSIO, against McNamara, 1956, 96 CLR 186, to say that buyers should generally conduct a survey. Again, you've got to raise this with your client, along with a multitude of things in conveyancing, and obtain your client's instructions. Let's assume for a moment that you do obtain a survey and there is an error in the survey. You're not sure whether it's a material or immaterial error, but your buyer agrees to proceed, but you can't agree on what to do about it. So your client wants to proceed. How would you go about looking at determining what is an appropriate compensation? I guess you'd ask for valuers, try and negotiate something. But if you couldn't, what remedy would you seek? Bearing in mind the clock is ticking, you've decided to settle, you've decided that you want to proceed to settlement, but you just can't agree on what's an appropriate compensation. Leone says withhold part of the purchase price, reduction of the purchase price. And I agree with those in general terms, but you've got to be careful because bear in mind that other clauses in the contract are still live. One of them is the requirement for a buyer to pay the balance purchase price. So are you taking a risk? If you've decided that the appropriate figure is $10,000, the other side say no, $2,000. If the price was $400,000 in total, would you turn up at settlement with the balance purchase price less $10,000 or less $2,000? Withhold part of the deposit, says Leone. I think the two ways you can approach it. The first is that you either try to have the matter resolved in a summary way through court proceedings. Have a look at Section 70 of the Property Law Act, which is where the court has the power to determine summarily the actual compensation, and that can be determined quickly, even potentially before settlement. Alternatively, settle. Pay the full amount, but specifically reserve your rights to compensation and sue for that amount. If there's a clear statement from the other side that the figure is $2,000, you may be able to get away with deducting $2,000, but I would be reluctant to go more than that. Now, I mentioned Section 70 of the Property Law Act. Has anyone looked at that section? It's really handy for conveyancing because it means that you have an opportunity, either as a vendor or purchaser, to apply in a summary way to the Supreme Court to deal with any issues to do with compensation or issues to do with interpretation of the conditions. Not going to the validity of the contract, but those things that occur on the way through. Here's an example of a case. It's Jarema, J-A-R-E-M-A, Proprietary Limited against Cato, K-A-T-O, 2005 1 QDR 592. So in this case, which deals with Section 70 issues, there was an office building, had a basement car park, and it was a 6-story office building. It was sold subject to leases and service contracts, and the basement car park allowed for pedestrian access, but no lawful direct access from the nearest road. At settlement, the buyer reserved an entitlement to claim compensation, and the parties agreed on damages in the sum of $85,000 if compensation was payable. And the point of this exercise was that the parties went to the Supreme Court using a Section 70 summons to ask whether or not they had to pay the compensation or whether or not they were entitled to receive the compensation. And it said, the court said the contract then provided for the buyer to terminate the contract if it was not the contract then provided for the buyer to terminate if access was not lawful, that is by public road. The buyer argued that that also implied compensation, but that the court in that instance rejected the argument. So the ultimate result was not that important, but it's the technique, it's the procedure that I'm really keen for you to understand. Now, Clause 7.7 deals with properties adversely affected. And that's an important provision for you to consider. Let's move on to terminating for material or substantial misdescription in the property or as to title. Now, have you heard of this, the rule in Flight and Booth? It's a very old case, more a property law case. But the rule in that case was that in relation to a misdescription as to property, the buyer is entitled to rescind the contract if the buyer is not getting substantially what they was bargained for. And that was applied in that Gordon Linton car sales case that I mentioned. So when it comes to issues to do with title being defective, have a look at Property Law Act Section 69. This is where it's a very grey area as to whether or not it's a buyer beware type situation or whether the buyer can argue that the title was defective. And the cases in the statute only apply in the context of misdescription of property or the vendor's defective title. It doesn't derogate from the general principle, let the buyer beware. So I'll mention that without dwelling on it, but so that you're aware there is an argument one way or the other. So if you can point to one provision or principle more than the other, depending on your circumstances at the time. Just a few words about insurance and risk. Now, at law, once the contract's signed, the buyer is responsible to complete the transaction, even if some intervening act which is not caused by the seller occurs. So if there's a natural disaster that causes damage to the property, at law the buyer is still required to complete the transaction. Now, for that reason, in my view, you should never change the risk clause in a contract. As tempting as it might be to where it says the contract or the property is at the risk of the buyer, as tempting as it might be just to cross that out and put seller, I wouldn't suggest you do that because of the legal position. But do bear in mind Section 64 of the Property Law Act, which provides a right for a buyer to rescind the contract if there is destruction or damage to a dwelling house to the point where it's unfit for occupation. That only applies for dwelling houses. That's Section 64 of the Property Law Act. There's a case, and the case is Dunworth against Mervac, 2011 QCA 200. In that case, the ground floor of a unit, which was in an off-the-plan contract situation, was flooded. And it was necessary to remove the lower level of the gyprock to disconnect the wiring. And a measure of the devastation of the flood was that the respondent required 4 months to complete the restoration work. A couple of things from this. So just when you have an off-the-plan contract, this is maybe relevant for the assessment piece, it's possible for it to be finished, but you haven't actually settled. So that's what happened in this case. At paragraph 38, the court said, it follows that because the unit was rendered uninhabitable, the appellant gained a right to rescind up to any date of the actual completion or possession, whichever was earlier. And the court made orders, a declaration that the buyer had validly rescinded the contract and was entitled to recovery of deposit in that case. Just a few more things and then we'll wrap it up for tonight. Have a look at Section 63, which talks about the application of insurance money on completion of a sale or exchange. It says, where after a date of contract money becomes payable under a policy of insurance maintained by the vendor, the money shall, on completion of the contract, be held or receivable by the vendor, or on completion of the sale, shall be received by the vendor and then paid to any person entitled to the money because of an encumbrance, but as to the balance, it's payable to the purchaser. So it's another avenue for the buyer to recover some funds. But usually, the buyer would have the policy of insurance. So the next topic, and where we'll pick up next week, which is case number 11, is to do with buyer access to the property before settlement. Now, as a general rule, if you're acting for a seller, you want to be very careful about allowing your buyer to move in. occupy the premises. I know it does happen and there's a lot of pressure at times, but gee, it's fraught with danger. Now, at law, there is no implied right for a buyer to enter the property before settlement at all. There are some provisions in the contract that allow the buyer access to the property after contract but before settlement, but it's limited. Have a look at clause 8.2. It allows the buyer to have access to the property to read the meter, but only once, for inspections under clause 4, and then once to inspect the property before settlement, and then once to value the property before settlement. So where we'll pick up next week will be case number 11, which is the buyer suspects the seller is interfering with the property. And I'll raise 2 scenarios for you to consider. So please think about that during the week. Keep up with your reading. And I know that we're still technically doing week 7 material, but that will be the end of the week 7 material. And next week we'll move on to the week 8 topics, which is contract to completion. But as you would have seen, we've got 2 weeks up our sleeves here for review and revision. So it's okay. We don't have to keep up. All right, any questions before we start, before we conclude for tonight? All good? Thank you very much for your patience, and appreciate you joining live for the sessions. Okay, so we'll see you next week. I'll wrap it up now, and all the very best. Bye then.